Greetings everyone, my name is Jonathan Bailey and I'm from the site Plagiarism Today, and today is kind of a slow news day, gotta be honest. It's a little bit on the thin side for news, and it's not my fault. I mean, it's your fault for not going out and infringing enough content to make it truly an interesting news day, so get on that. But the point is, it's like I said, a slow news day, so this is an excellent opportunity to kind of backtrack a little bit and talk about something I've been getting a few emails about and something I've gotten a few questions about, and that is, what does the Perfect 10 v Tumblr case mean for Pinterest? Might seem like an odd topic, but it's actually been on a lot of people's minds, and it came up on a recent This Week in Law that I was on with Denise Howell and company, so it's worth taking a few moments to talk about. To recap what's going on here, Perfect 10 is a pornographic site that sued Tumblr, the microblogging service I'm sure we're all at least somewhat familiar with, alleging that Tumblr had ignored several DMCA notices sent, and as a result of that, some 200 plus of Perfect 10's images remained on Tumblr's servers and service illegally. And since it didn't respond to appropriate DMCA notices, once again, to solve Perfect 10's theory here, therefore, Tumblr has waived its right to safe harbor and is therefore partially liable for those images being on their servers. There's a lot interesting about the Perfect 10 case in this. Perfect 10, of course, has a very robust history in copyright litigation. No stranger to being a plaintiff in these matters. It sued Google not once but twice, and has sued other companies over DMCA matters as well. It's a very strong tradition for them. And they've lost pretty much every single case they've raised. So a lot of people aren't taking Perfect 10 very serious in this matter, and I understand that. But there is a lot that distinguishes this case from other Perfect 10 efforts. One of the things being this case is being tried in the Second Circuit, not the Ninth. The Ninth Circuit is where Perfect 10 has had pretty much all their defeats. And the Ninth Circuit is a very ISP host intermediary friendly district on DMCA matters, on these takedown and safe harbor matters, where the Second Circuit might be a little more favorable to plaintiffs in these cases. So I guess we'll have to see. But the point of the matter is, there's a lot interesting in this case, but I don't see how too much of it applies directly to Pinterest. The copyright issue with Pinterest is whether or not Pinterest, by encouraging people to repin and pin and grab things from anywhere they see it on the web and share it on their pin boards, whether or not the structure of the service means they are inducing copyright infringement. And that's a thorny question, to say the least. That's a tough one that I think Pinterest is going to have to deal with, because even though it's trying to address a lot of these copyright issues with attribution improvements, DMCA improvements, etc., they're not getting to the core of the problem. The core of the problem is basically their entire business model centers around grabbing images and copying them to their servers and encouraging people to grab from whatever from wherever they see it. So they might still be potentially facing some serious liability issues there, but it's not directly related. I know Perfect 10 does make some arguments on this front, saying that, since it's a photo blogging service, it's encouraging people to take images from elsewhere on the web and repost them on Tumblr, but it really isn't the same service, and any ruling on whether or not Tumblr induced copyright infringement wouldn't likely have a lot of impact on the Pinterest case, because you're looking at two very different situations for the most part. So I don't really see too much relevance here between these two cases, and besides, most of the Perfect 10 v Tumblr case hinges on whether or not Tumblr ignored legitimate DMCA notices, and also a second factor of the case is whether or not Perfect 10 can show, as it claims, that Tumblr employees used Perfect 10 content to see the site. And if you've heard that argument before, that means you've been paying attention to the Google v Viacom case, or the Viacom v Google case, I should be saying it. And at that point, you win a cookie or something. The YouTube Viacom case, of course, being that being one of the central arguments of that case. So, honestly, as interesting as the Perfect 10 case with Tumblr is, and as many questions as it does raise, it doesn't have a lot of direct implications for Pinterest. And a lot of it's just because Pinterest is such a unique service. It's such a new idea, for better and for worse. It's going to be something where we're going to have to wait and see what happens when someone actually sues Pinterest directly before we get answers truly relevant to Pinterest. I know that there are companies that are thinking about it. I know there are companies that are kind of on the warpath here. A lot of the stock photo agencies, such as Getty Images, reportedly are biding their time right now, but are still kind of contemplating where this fits into the future. Maybe then we'll see what happens. But obviously, I don't think it's going to be Perfect 10 that files the suit, because I don't believe Pinterest allows pornographic content on its service. So even though Perfect 10 is a very frequent plaintiff, I don't think they're going to be the ones to go after Pinterest for obvious reasons. Well, so that hopefully addresses that issue at least somewhat. If you have any further questions or comments, please leave them below. Leave them on the Facebook page. Send them to me via Twitter, wherever you see this, or Google+. Wherever you see this, please leave your comments, thoughts, questions. Happily take a look at them and see about answering them in a future edition of this. But in the meantime, this is Jonathan Bailey, signing off.